This is docket 25-4290 FH, People of the State of Michigan versus Bryce Spitzley. Counsel, your appearance for the record.
Yes. Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Christopher Wickman on behalf of Mr. Bryce Spitzley, who is present and standing to my right.
Please raise your right hand. Do you swear or affirm under penalty of perjury?
I do.
Thank you. Put your hand down. And sir, you're taking any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any marijuana, alcohol, other substances?
No.
And any sign of fever, COVID, or other illness? Do you still reside on Dennis Road?
Yes.
And who do you reside with?
Myself and my kids.
And how old are your children?
13 and 12.
Are you the custodial parent?
Yes.
And anyone else in the house?
My daughter every weekend comes over, and then my girlfriend stays there.
Okay.
She also has her own place, so.
Does your girlfriend happen to be Ashley Stinson?
No, Your Honor.
Okay, great. Now, were you on probation, parole, or bond conditions when these other offenses happened?
No, Your Honor.
All right. What are we doing here today, counsel?
Your Honor, today is the date and time for a final pretrial conference. The people are going to be requesting a brief adjournment for the trial date in order to get the medical discovery. So purpose today is.
Why don't you have it already?
It fell through the cracks. I've talked to the detective as recently as yesterday. We're handling it now.
When is the trial date?
It's scheduled for April 17th. We're asking for adjournment. Honestly, even just a month out to, I think we had already looked to see May 29th as backup trial there. But even on that day for April 17th, it's like 7th or 8th down the list.
Where are we in May?
29th, I think 4th.
Oh, that would be the new trial date?
Correct.
And what about the new final pretrial dates? Is the final pretrial, is the offer going to change based on the medical evidence?
I don't believe so, Your Honor. The offer's been the same since the initial pretrial conference. There's not been a counteroffer. If there is a counteroffer, as a result of the medical evidence, there's more negotiations, and we feel this can be resolved without trial, I'll contact the court as soon as possible.
All right.
But the plan is for a trial.
Well, the plan right now is to move on to the final pretrial. If you find something that's going to change your offer or the circumstance, you let me know and we'll have another final, but it's the final. So what's
Exactly.
the offer?
The offer is for the defendant to plead guilty to a count of assault by strangulation and then 2 counts of misdemeanor domestic violence, one of which will be added on. As charged, the guideline range is 36 to 71 months. And with the offer, it comes down to 12 to 24.
So then count 1 would be dismissed. You'd be pleading to count 2. Assault with intent to create bodily harm, less than murder. Is that right?
Yes, as well as a misdemeanor domestic violence and then an added count of domestic violence.
So you would have count 3 and 4 were dismissed at preliminary exam, and then you'd be pleading to count 5 and 7, which would be the added DB.
Correct.
And then count 6 would be dismissed on count 1. Do I have it right?
Yes.
Okay, full, fair, accurate, and complete.
That is in fact their offer, Your Honor. I haven't calculated the guidelines on the offer. It's not an offer. My client is earnestly considering this matter. We had asked for this case to be dismissed based on the other evidence. The court did a motion to quash on it and express concerns. The prosecutor's office, both with Mr. Kwasnick and Mr. Carino, have declined to dismiss the case. So it does look like a matter we're sitting for trial.
All right, is the offer that was made full, fair, accurate, and complete?
Yes, Your Honor.
And it's your desire to go to trial?
Yes, Your Honor.
All right, and did anyone force, threaten, or coerce you to make this decision?
No, Your Honor.
Did anyone promise you anything that caused you to make this decision?
No, Your Honor.
And you made this decision of your own free will
Yes.
after consulting with counsel?
Yes.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
All right, so this is going to remain on the trial docket. If there is evidence that arises that changes the landscape here, certainly will entertain another final pretrial, dismissal, amendment, whatever. I don't know, and I don't have a crystal ball. I don't know what's gonna be found or not. So plan on going to trial unless circumstances change, and I know your attorney will talk to you about all of that, and you'll all keep me informed, but right now, we're done, we're ready, we're getting ready for trial. All right, bond and bond conditions are continued.
Briefly for the calculation of speed trial, Your Honor, the defense objects to the adjournment. We did request these medical records way back even before prelim. We're disappointed we don't have them. I understand the court is going to grant the adjournment, especially since we were already 7th on the list for April 17th, but just for the calculation of speed trial, we did want to object to that. Thank you, Your Honor.
All right, so noted. Thank you.
Thank you, Your Honor.
What was that trial date?
29th.
May 29th.
Thank you.
And
Thank you,
then,
Your Honor.
and Mr. Nichols will be taking over this case, Your Honor. Thank you.
Thank you.
Your Honor, can we approach?
Yes.
Yeah.
Quiet. Or these are.
Romero, sit down for a second.
We are back on the record on docket 25-6826FH. Counsel and defendant are present, sir. I'm just going to remind you that you are sworn. And I understand from a brief conference at my bench that you and your attorney have had additional conversations, and that it is your intention to avail yourself of the plea agreement and try again at the factual basis with some additional information. Is all of that correct?
Yes.
And the people are in agreement we should go forth with this?
Yes, Your Honor.
All right, counsel, perhaps you should inquire of your client.
I think that would be wise. Thank you.
I think so too.
All right, Mr. Barber. Picking up from where the judge left off on the factual basis, you recognize that you were pulled over on November 25th, 2025 with cocaine in the car, correct?
Yes,
Prior to that, did you have a conversation with your wife over on the telephone?
yes, shortly before that, yes, I did.
Yes. And your wife told you that she had given a ride to a friend of yours who you happen to know is a cocaine user, correct?
Yes,
And that person had potentially and actually did leave some substances in your car, correct?
yes,
Specifically cocaine, correct?
yes,
And you were aware of that it was possible that it was still in your car when you took possession of that car, correct?
yes, I was.
And you drove it anyways,
Yes, I did.
knowing that it was potentially still in there.
Yes, I did.
So you would acknowledge on the record that you had reason to believe there was
There
cocaine
is
in that
possible,
car.
yes, yes,
And you failed to check your car and verify that it was clean and free of substances. Is that correct?
yes. It is.
On behalf of the people?
The people are satisfied, Your Honor.
Defense would be equally satisfied, Your Honor.
All right. Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Or comply with courtroom?
You have, Your Honor.
You have, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find at this time, based on the additional statements that were voluntarily made by Mr. Barber after further discussion with his attorney, that there are sufficient grounds to accept defendant's plea. Therefore, count one will enter. Any outstanding warrants, if any, are hereby recalled and dismissed. Any contraband seized is hereby forfeited. We have sentencing date.
May 27th at 11 a.m.
Does that meet with your schedule, counsel?
It absolutely will, Your Honor.
Sir, you'll need to make and keep an appointment with probation. Counsel, if you could show them downstairs, that would be easier than you calling, but if you don't have time today to stay, that number is on the sheet that we're giving you, and it's 483-6100-517. And so you'll need to call that number within 24 hours and make that appointment with probation. They're going to do a very detailed pre-sentence investigation report that we'll all talk about at the time of sentencing. Bond and bond conditions are. Great, you have that sheet.
This is what out here, Judge.
Ahead of time paper, sheets. All right, if you could just wait a moment when we get that sheet to you.
Absolutely, Your Honor. Feel free to see that.
As soon as we get the next.
There's actually two cases woven into one session. Bryce Spitzley's pretrial conference, followed by the return of Jeremy Barber, who came back to try his plea again after Judge Aquilina had rejected it earlier. Bryce Spitzley stood before the court facing serious charges: assault by strangulation and domestic violence counts. The prosecution had an offer on the table: plead guilty and watch the sentencing guidelines drop from a range of 36 to 71 months down to 12 to 24. Spitzley's answer was simple: no deal. He wants a trial. His defense had previously moved to dismiss the case entirely. The court had expressed concerns, and prosecutors had declined. Medical records the defense claimed to have requested even before the preliminary exam still hadn't been produced. A lapse the prosecution admitted fell through the cracks. And the trial was adjourned to May 29th. Spitzley walks out on bond, headed toward a courtroom showdown. Then Jeremy Barber came back. Earlier in the session, Judge Aquilina had stopped his plea cold, unwilling to accept a factual basis that didn't hold up. But after a quiet bench conference, Barber returned with something the court needed to hear. His wife, he explained, had told him before he got behind the wheel that a friend, a known cocaine user, had been in that vehicle and may have left something behind. Barber drove it anyway, knowing, without checking. That was enough. Judge Aquilina accepted the plea. Count 1 entered. Sentencing set for May 27th. Two very different men, two very different outcomes. One courtroom that demanded the truth and didn't move until it got it. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.